Hello, this is R.J. Deacon, reading the Supreme Court of the United States opinion syllabus in Apple Incorporated versus Pepper, certiorari to the United States Court of Appeals for the Ninth Circuit. Argued November 26, 2018. Decided May 13, 2019. Apple Incorporated sells iPhone applications, or apps, directly to iPhone owners through its App Store, the only place where iPhone owners may lawfully buy apps. Most of those apps are created by independent developers under contracts with Apple. Apple charges the developers a $99 annual membership fee, allows them to set the retail price of the apps, and charges a 30% commission on every app sale. Respondents, 4 iPhone owners, sued Apple, alleging that the company has unlawfully monopolized the aftermarket for iPhone apps. Apple moved to dismiss, arguing that iPhone owners could not sue because they were not direct purchasers from Apple under Illinois Brick versus Illinois. The district court agreed, but the Ninth Circuit reversed, concluding that the iPhone owners were direct purchasers because they purchased apps directly from Apple. The Supreme Court affirmed, and Justice Kavanaugh delivered the opinion of the court, in which Justices Ginsburg, Breyer, Sotomayor, and Kagan joined. Justice Gorsuch filed a dissenting opinion in which Chief Justice Roberts and Justices Thomas and Alito joined. Under Illinois Brick, the iPhone owners were direct purchasers who may sue Apple for alleged monopolization. This straightforward conclusion follows from the text of antitrust laws and from this court's precedent. Section 4 of the Clayton Act provides that any person who shall be injured in his business or property by reason of anything forbidden in the antitrust laws may sue. That's 15 U.S.C. Section 15A. That broad text readily covers consumers who purchase goods or services at higher than competitive prices from an allegedly monopolistic retailer. Applying Section 4, this court has consistently stated that the immediate buyers from the alleged antitrust violators may maintain a suit against the antitrust violators. Kansas versus Utilicorp United Incorporated. But has ruled that indirect purchasers who are 2 or more steps removed from the violator in a distribution chain may not sue. Unlike the consumer in Illinois Brick, the iPhone owners here are not consumers at the bottom of a vertical distribution chain who are attempting to sue manufacturers at the top of the chain. The absence of an intermediary in the distribution chain between Apple and the consumer is dispositive. Apple argues that Illinois Brick allows consumers to sue only the party who sets the retail price, whether or not the party sells the good or service directly to the complaining party. But that theory suffers from 3 main problems. First, it contradicts statutory text and precedent by requiring the court to rewrite the rationale of Illinois Brick and to gut its long-standing bright-line rule. Any ambiguity in Illinois Brick should be resolved in the direction of the statutory text, which states that any person injured by an antitrust violation may sue to recover damages. Second, Apple's theory is not persuasive economically or legally. It would draw an arbitrary and unprincipled line among retailers based on their financial arrangements with their manufacturers or suppliers. And it would permit a consumer to sue a monopolistic retailer when the retailer set the retail price by marking up the price it had paid the manufacturer or supplier for the good or service, but not when the manufacturer or supplier set the retail price and the retailer took a commission on each sale. Third, Apple's theory would provide a roadmap for monopolistic retailers to structure transactions with manufacturers or suppliers so as to evade antitrust claims by consumers and thereby thwart effective antitrust enforcement. Contrary to Apple's argument, the 3 Illinois Brick rationales for adopting the direct purchaser rule cut strongly in respondents' favor. First, Apple posits that allowing only the upstream app developers and not the downstream consumers to sue Apple would mean more effective antitrust enforcement, but that makes little sense, and it would directly contradict the long-standing goal of effective private enforcement and consumer protection in antitrust cases. Second, Apple warns that calculating the damages in successful consumer antitrust suits against monopolistic retailers might be complicated. But Illinois Brick is not a get-out-of-court free card for monopolistic retailers to play any time that a damages calculation might be complicated. Third, Apple claims that allowing consumers to sue will result in conflicting claims to a common fund, the amount of the alleged overcharge. Illinois Brick. But this is not a case where multiple parties at different levels of a distribution chain are trying to recover the same pass-through overcharge, initially levied by the manufacturer at the top of the chain. The decision again is affirmed. Justice Kavanaugh delivered the opinion of the court, in which Justices Ginsburg, Breyer, Sotomayor, and Kagan joined, and Justice Gorsuch filed a dissenting opinion in which Chief Justice Roberts and Justices Thomas and Alito joined. Thank you for listening. If you'd like to get a hold of the podcast, we can be reached at RhodesScholar80 at gmail.com. That's ROADS and 80.